Chairman. My Lord, I like to mention item number 13 from the hearing. And for the petitioner, Mr. Seneza for the government side, my Lord.
Item number 13.
One thing, my Lord. In this case, my Lord, I just, while seeking adjournment, on the 27th of June, there was an order passed by this honorable court, my Lord, stating to bring some original certificate of the registration and also some other relevant documents, my Lord. Those are in my custody, my Lord. Today, the purpose of seeking adjournment is, my Lord, if I would like to file in the form of an affidavit, my Lord, or should I just produce it, my Lord, at the time of the hearing?
Sorry for something, let the matter be brought. It would be very better to see the last order and then.
Item number 17. Yes, we would like to see 3 weeks adjournment. We have filed certain documents to the registry which have been marked defective. So we will need some time to resubmit these documents. Actually, the petitioner stays in Delhi.
This is criminal petition.
Yes, sir.
That is against an order of conviction by security court.
Yes, by court martial.
Okay. We are not recording anything else, we will just adjourn it.
Yes.
2 weeks.
3 weeks.
Gotcha.
Yes, item number 17. Spread for Mr. Private counsel for the petitioner. And not objected by the counsel for the respondent. This is 3 weeks.
Alright.
I do appreciate.
I'd like to mention item number 18.
18. The last item.
Yes, Your Lordship.
Yes.
I need to pray for 1 week's time, Your Lordship. I want to bring some important documents on record, Your Lordship. So I humbly pray, Your Lordship, I may be allowed to file a bill of affidavit.
If the need, you could just adjourn it. Literally anything.
Nothing to say, Your Lordship. He's asking for a
Court did not notice that you were standing in the You can adjourn it for this thing because
23 matter also.
this is 23 matter and then she said that she wants to bring us some certain documents. Let her do it. Okay. This is also spread for a joint counsel for the petitioner. This is matter after a week or 1 or 2 weeks.
1 week, Your Lordship.
Let it be 2 weeks, Your Lordship. 2 weeks.
After 2 weeks.
Apply.
Okay.
Please, Your Lordship, I beg to mention item number 9, Lordship. Yes, currently I am believing, Lordship. His lease has expired. Because what is related is expired, Lordship.
Item number
Item number 9, Lordship.
This is Your Lordship. What is this? Item 9 is adjourned, then item 10 and 11 will have to be adjourned.
Yes, Lordship.
Because these are all connected.
any objection from this?
No, so far, if that is the case of derailment, then
Yes, that is it. Okay, item 9. Mr. Swanson. Are you an advocate on record?
No, Lordship.
Mr. Swanson. Private counsel. Submits that Mr. Session. Counsel for the petitioner is out of station. And brings that matter be adjourned by
2 weeks, Lordship.
books. Mr. Fulai. You are the only respondent or any other. Just a record of the names. Okay. The so-and-so. Counsel for the respondents have no objection. Yes, this matter after 2 weeks.
Obla.
and your vice versa. Then 10, 11
10, 11.
is Mr. Sheikh, is the same thing, he is counsel for the petitioner. 10 is Mr. Sheikh, so same order will do 10. And then 11, Sheikh is Mr. Sheikh is not there. But then it is connected. So anyway, just 11 just say list for 2 weeks. Let's wait for the parties.
Apply.
19 11 just 50.
May I please, Your Lordship, I beg to mention item number 8.
I mean, ready?
We're not doing it. If you're ready, we'll do it.
My senior counsel, due to
Sanmai is ready.
my senior counsel is due to personal difficulties. He could
Who
not
is senior counsel?
as they.
Yes, there is. Where he is? He's not here.
Due to personal difficulties, he could not come to court, Your Lordship.
This is 2018.
Yes.
What is the matter about?
Actually, this is regarding the service matter. I was just
You are in service or you are out of service?
actually what happened. Actually, they practically didn't allow me because there is no weekend post because they have.
You are still in service.
I'm no more in service now.
There is no interim order also.
Where is the motor? Actually, in my place, private respondent was appointed.
We can resume it today.
Yes.
Can we?
Yes, Lordship.
For how long?
2 weeks, Your Lordship.
Your state is also. Okay. Prayer has been made on behalf of Mr. S. Counsel for the petitioner. No, sorry, for the respondents. Respondent number?
Respond number 324.
To adjourn the matter. On the non-availability counsel. The learned counsel for the petitioner. This is the foundation. Have you done this system of 2 weeks?
Lordship.
So, please, Your Lordship.
Item number 1.
Please, Lordship. Yes.
Lordship, there is the land acquisition matter where the issue of ROW is concerned, and as it is, this matter is pending, similar matter is pending before division bench. So, and as per the last order,
This is a tax discussion, similar matter is pending before
Not a
division.
similar matter, that will have some sort of an impact. Some of the petitioners have
And the last order, see, last adjournment was on different,
yes, we're supposed to
we are supposed to get the names of the petitioner, those who have received the compensation.
Right. But due to some difficulty, the parties are unable to come.
Let us address that issue, then we will come to the other issue.
Yes.
So what happened to that part?
Lordship, the parties are yet to come, and we've tried contacting them.
You have not collected this information.
Lordship,
So how many petitioners have got?
there's compensation that are yet to come. So I kindly pray for another 3 to 4 weeks time, Lordship.
See, in the last petition also you were given 4 weeks time.
Lordship, as it is because this.
the order dated 15/6/23. The Union government had placed on record
Zimma.
Now, he has made a series of prayer, including that the order passed under the Zimma be recalled, revoked.
It's okay. It's all right. Just wanted to go to things. Let him place. Otherwise, matter is ready.
My lord, I am only for one of the respondents, my lord. There are about 6 respondents here.
All are necessary. All are necessary parties.
Actually not necessary, because they are supposed to be fictitious parties. I have made them parties under care of
They are pro forma respondents. But the notice was issued to them.
Yes, care of the same, because
My lord,
it has come through that only.
I
Yeah,
have this.
same.
See, how can they be under my care, my lord?
My lord, they
Anyway, we'll just see whether their appearance is required or not. We'll just see. If it is Jimma,
My lord,
I don't think the question would be limited.
limited question.
So that is where. Now the thing is that, are you ready? Ready for?
yes, it's a very simple matter.
Yes, then you can proceed then. Yes, tell us.
They,
Was it your vehicle?
pardon?
Your personal vehicle?
Personal matter. You know what happened? The cases like this, I answering to the advertisement through Meghalaya OLX group.
You have taken Jimma of his personal vehicle.
No, my lord. The vehicle is registered in my name. My lord, what has happened is that
This is
there
a
was.
colleague, that much is not expected. Yeah.
My lord, what happened is he responded to an advertisement in a
Let him please. Okay.
electronic platform.
Then I paid 2,57,649 rupees totally
To whom?
to the
For which vehicle?
for the
Now you give me in details. If you say something, the court must get the fact first. This vehicle,
yes.
it belongs to you. You are the registered owner.
No, it's not registered in my name. What happened? Answering the advertisement, I contacted, and through GPay I made the payments in parts. Then they were supposed to
To whom?
to the contact in the Facebook. That is one Sahil Kumar and one
To some private
Vikas
person.
Kumar.
To some private person.
Those are private persons.
You are Sahil Kumar.
No, I am not Sahil Kumar.
Okay.
No, Vikas Kumar and Sahil Kumar, they were the persons I contacted. Then I made the payments. Then when they were impersonating as army people from Narangi. So I had my friend in Narangi posted there, so I contacted him on the second date, on the 12th. And that friend confirmed that there is no such organization in Narangi unit selling cars like this. Immediately, under his advice also, immediately I reported the matter to the cyber cell in Shillong, DGP's office. Cyber cell took the online FIR, then instructed me to file a formal FIR in the Sadar PS. Accordingly, on 16th, I filed a FIR giving all the details of the payments through UTI. Then the IO had taken quite some time, till about 5 months. There was no any clue. So I filed one writ petition. Answering the writ petition, the police speeded up the investigation. Notice under 41A was issued. Answering to such notice, he surrendered before the police with the vehicle for which I had paid the money.
But then you are not paid to him.
No, through this, I paid for this vehicle.
But then money has not gone to his account.
I don't know.
Where is your money
does
receipt? Where is your money receipt?
That the police is
No,
still
the
in
payment
inquiry.
receipt. Where do you have?
The
Have you
investigation
enclosed
is
it?
still on by the police, actually, my lord.
It is not enclosed with the.
No, the investigation is with the police. It's not yet
So
completed.
your
We can-
payment.
No, only now what happened? He surrendered. Now I had paid money for that vehicle which he has surrendered. Hitesh Brahma. After surrendering, my lord, kindly see the order on page 32. Sierra Putap, etc. Seen and peruse Jimma application number so and so, filed by the petitioner Sri Jagat Brahma. Petitioner is Jagat Brahma. The vehicle has been given in Jimma to Jagat Brahma, whereas Jagat Brahma is not the registered owner. Registered owner is Hitesh Brahma. That is the gross mistake by the court below, my lord.
So this Jagat Brahma is not a party here.
I have made him also party, I think. No, I have not made him. He is the father of Hitesh Brahma.
You should have made him a party. If you want to make a distinction between these two, then definitely you should make him
My
a
lord,
party.
I may be given 1 week's time. I want to amend this and make him a party, my lord. That's pertinent, yes.
What is your paragraph 7? Read your paragraph 7.
Yes, ma'am.
At page 6. Come to page 6 if you're.
That as stated under paragraph 4 above, the writ petition so and so was proceeded and after.
Yes. Come to now read paragraph number 4. What is written in paragraph number 4?
That although the price was advertised as
Then
1,50,000, only the culprits received more
that
than
is okay.
such.
Then your paragraph number 7 is wrong. What you have drafted, you see, you'll make this code confused. You see, you say one thing in one paragraph, you say another thing in another paragraph.
I may be allowed to correct.
You withdraw this petition, file a
including
proper
the
petition.
addition of the other.
See,
party
this is
also, my lord.
this. I do not know.
Yeah,
This
I'm
has
getting
become
confused
a
because
kind of
of-
puzzle for the code.
Whether the typist place some lines or not, I'll have to check once again, my lord.
You withdraw this application, file a proper application.
I'll do that, my lord. That's better.
Yes. Mr. P.K. Bora, learned counsel for the petitioner. Oh, sorry, learned petitioner, appearing in person.
Simply petitioner, my lord. Learned shouldn't be there.
Right. It's okay. Mr. P.K. Bora, petitioner appearing in person, makes a prayer for withdrawal of the matter
Copy of the Zimmer petition.
with the liberty to file afresh. Mr. You write K.C. Gautam, you write K. Gautam.
KC Gautam.
K.C. Gautam. Appearing for the.
Respondent number
Oh, and
number 2.
Miss Shyam, MS Shyam. Waiting for the respondents. Have no objection. The matter stand dismissed on withdrawal with liberty as prayed for.
Obliged.
Item number 3.
Yes, where is Mr. Sengupta? Oh, actually, you must have.
It's on deck.
So, what is to be done?
This,
He wanted some instructions.
the petitioner is supposed to implead this complainant. Whether the petitioner is impleted.
This is respondent number 2. Is it respondent number 2? Complainant. Notice has been served. They have filed an affidavit of service. Who is respondent number 2?
Complainant, Your Lordship.
Complainant. Yes.
Then
They have made person has been served by them, though he has not entered appearance. So what is to be done?
let this matter come out after 2 weeks for hearing, Your Lordship. In the meantime, I'll take instruction, Your Lordship.
This is otherwise ready for hearing.
Then because I have not received the detailed instruction, so I may be given 2 weeks time to take detailed instruction, Your Lordship.
Yes, on the prayer of Mr. H. Abram, Learned G. List this matter after 2 weeks to enable him to procure necessary instructions in the matter.
Hello, Pledge.
Much play.
Hearing item number 6.
You say, Nathan, you say to enable him to obtain, not procure, obtain. Yes, Mr. Jha.
My lord.
Service matter. Assam Rifles.
My lord.
Yes.
Lordship, the learned TSGI is on legs.
Adjournment.
My lord, for proper assistance, my lord. This is matter pertains to the ACP, Grant of Assured Career Promotion, and MSCP, Modified Assured Career Promotion, my lord, which requires some preparation from my side.
It's 2017 matter.
My lord, I will let it come next week.
From 17 to 23, 6 years have gone.
My lord, point is very limited, my lord. Here, they are treating as a remonstration or upgradation as a ACP, means giving financial benefit, my lord. So that I will satisfy, my lord. Next week, my lord.
Yes, Mr. Mojiga.
He has to open the case.
How many cases are there of this nature? This kind of
three matters.
Now you say assured career progress. They have to come to the court for that assurance that their career progresses. Why you make some scheme when you do not assure somebody?
We've assured and insured also, my lord. The problem is they are not satisfied, my lord.
So there is no real assurance from your part. You just name it.
Not only assurance, we've insured also, we've granted, my lord.
Anyway, respectful by Mr. Arja. Mr. Jha, we should basically finish those matters, 2017 matters. Whatever this way, that way.
My lord.
Okay, this court, because Assam Rifles matter, this court also will take time to understand.
My lord.
Because I am not very, you see,
it's a long history of this case.
Long history plus those nomenclature and all, whatever you use it, I find it quite confusing. So I'll take time.
This
to
matter,
digest
Mr.
it.
Jha, today's Wednesday, you can do on Thursday. It will not for seasoned counsel like Mr. Jha will take 1 hour preparation.
My lord, it's
you can do it tomorrow, day after tomorrow also.
He's asking for one extent. Let us see. Respectful by Mr. Arja, Land Counsel for the petitioner. List this matter after 1 week. Dr. Majika appearing for the respondents. Have no objection.
After a week.
After a week.
Hello.
Item number 7.
Yes. Now you are not appearing in person.
Not in person. On the previous date, we had come to the order dated 26.
What is the matter about?
Job card holders claiming unemployment allowance and compensation.
Who is appearing for the other side?
Mr. Karni had appeared before on the previous date.
Was this matter argued before other bench
Yes,
also?
yes.
It was argued before other bench also.
Yes, madam.
But then that is not been kept part heard.
It had been heard several times actually, and ultimately
There are some.
I was asked to show the authority because I had been ousted from secretaryship. So, as per the order of the court, I had shown the authority by the other job card holders for proceeding with the case.
Job card holders of which village?
Of Chirakata village in.
How many job card holders are there in that village?
The claimants are 104, but as per the list, there are 300 job card holders.
So all are not before this court.
All are not involved. Only there is due against them only. Others don't have any due.
So it means who are you? You are secretary.
I was secretary.
So if you are secretary,
the new secretary was appointed, I was no more secretary. Thereafter, I was asked to show the.
So
authority.
you are not representing the entire VEC. Only some members.
Some those any due against
these members are not named here. In your writ petition, they are not made a party.
They
may be authorized, but then they should be individual made a party. See
well,
the High Court rules.
As a secretary, because you
have to pay a stamp for each and everyone.
Job card holders, very poor people.
You are secretary. If you are secretary, then you will make a prayer for all 300 plus. But then you have come for only for the causes of some of the.
My lord, the other persons had no due payable to them.
I understand, but then try to understand how you justify you represent them as a secretary.
I had all the records as a secretary. I knew only these persons had dues. They had only worked. Others had not worked.
There must be
people are having job
card holders. They
don't go for work.
You are not ready to listen. You do not want to come to the issue. How you see, if you represent yourself, if you say that you have a locus standi to file as a secretary, then you should represent all the 300 persons. Now all the 300 persons, they do not have any grievances to be redressed. Only a part of those people, 104.
Yes.
Then this 104 should be named as petitioner.
Yes, my lord. That is.
You have not come for common cause of the entire village council. Why don't you understand that?
My lord, I had come for the same interest of these 104 petitioners under Order 1, Rule 8, and there was no objection.
What are Rule 8 applicable in writ petition? Does it apply provision of CPC?
No, not.
You said you have come under Order 1, Rule 8.
But then thereafter also, when this was discovered, I was asked to show the authority, and the opposite party had no objection. As per the order dated 26 October 22, I showed the authority.
If some people are not named as petitioner, how they will give you authority?
My lord, the court had passed an order asking me to show the authority that way, and I have shown it that way. Respondent had no objection on that.
See, you have until and unless
that is why I had left the case.
Are made a party. This court will not entertain any prayer made.
So I have left the matter
Are you still a secretary of the?
I'm not secretary. That is how it happened.
So you do not have.
We started from 2018.
See,
then 2022, I was asked to show the authority by that order. I complied. Thereafter, I leave it to the discretion of the honourable court.
This court is not satisfied with your explanation.
I leave it to the discretion of the court.
Heard Mr. P.K. Bora, not a counsel for the petitioner. the petitioner claims to be a secretary of the VEC, Village Employment Council. See your paragraph 1, what do you say of the writ petition? It means you give misleading submission also. Your bona fide is in question.
Yes, madam.
Which is comprised of 104.
At that time, it was 104 only. Now, this list of 300 was, there is a story also. This list was given by one self-styled headman of the village, against whom a writ petition
Your
was
writ
filed.
petition doesn't clarify all those things. This sexual aspect you are making in your submissions, but then it is not there. Now, you have made a statement in your writ petition wherein you say that VEC comprised of 104 job card holders.
At that time, 2015, it was 104. Number has increased now. It has reached to 300. There are many new in the vouchers who have become job card holders later. At that time, 2015, there were only 104.
You filed this case in 2018.
Yes, my lord.
So 2018 also there was 104 members.
Yes, my lord.
We'll verify that. If it is not correct, then you will take the responsibility. Hard, mister. PK Bora, Land Council for the petitioner. Submits that the petitioner filed this writ petition in the year 2018 in the capacity of Secretary of the VEC of Chirakata village under Morsindran block of West Kasi Hills, which is comprised of 104 job card holders. Give a full stop. The writ petition does not disclose the name of any of the job card holders except the petitioner himself, though a prayer has been made. On behalf of all the job card holders. It has been submitted that at present, from when he ceased to be a secretary, petitioner?
From 2021. 2021, I think.
Just what to say?
Ceased to be the secretary.
It has been submitted by the Learned State Council that the petitioner ceased to be a secretary of the secretary of the Village Employment Council of Chirakata village.
2021. From 2021.
From 2021.
Yes.
You do not have a specific date.
He was secretary till 2021 only. After that,
no specific date is there.
Specific date, I think in March, because in March.
Do not say a thing. You see, on the thing basis cannot be. A thing cannot be a basis for passing in judicial order.
Yes, it is not notification also. Affidavit.
Because in my affidavit, Lordship, the date of the election was 12 March 2018 and approval on 27 March 2018. So his term expired in 26 March 2021 for 3 years.
What did you say? Just last night? The submission by the learned. with effect from the
27 March 2021.
With effect from 27 March 2021. Stop. He further submits that VUC at present consists of more than 300 members. Since the petitioner is no more a secretary of the village, he cannot represent the member of the VUC. More so when all the members of the VUC do not have grievances to be redressed by this court. Give a paragraph. A careful perusal of the writ petition makes it clear that no detail of the said 104 VUC members has been mentioned. Neither there is any authorization by any of the VUC members authorizing the writ petitioner to file this writ petition on their behalf. What about you? What your personal? Do you have your personal grievance here?
I'm also a job card holder.
You're a job card holder, and you also have the same grievance.
Not through my name, through my relative's name, because my job card is a family.
So you do not have a grievance. Your personal grievance is not involved here.
No, not involved that way.
It is submitted by the London Council of the petitioner that petitioner personally does not have any grievance to be redressed by this court. Give me High Court. High Court. High Court rules. It is surprising that how petitioner do not write that right. Just say you refer to some affidavit filed by you. You refer to some affidavit filed by you.
Yes, my lord.
Bringing in your authority. Where is that? Where is that?
I filed it on November 22, I think. Exact date I couldn't find here. 26 October was the date. Within a week I had filed. I forgot, date is not mentioned in my copy.
Date is not mentioned in your records.
My
Then
copy.
in whose record it will be
But
mentioned?
it was within a week, my lord, after 26/10/2022.
Is an affidavit by the petitioner as per order dated 26/10/2022?
Yes, my lord.
26/10/2022.
Acha. It appears from the record that pursuant to order dated 26/10/2022, 26/10/2022, the petitioner has filed
Even
an
Lordship,
affidavit.
in this meeting also it is doubtful, Lordship, because not attended by the
That is what. See, his
headman of the
government is
village.
paragraph 1 and see.
Paragraph 1. Not attended by the headman also.
No, whatever it is, they must be included as a party, you see.
Yes, Lord.
I think there's a provision in the High Court rule. Okay, when one person files writ petition on behalf of others,
Yes.
one person authorized. Whatever one rule, it will not come here. Anyway, it appears on the record that pursuant to order dated 26/10/2022, the petitioner has filed an affidavit to bring on record the purported signatures of signature of all the 104 job card holders of all the 104 job card holders. Approving the petitioner to pursue the matter. However, the said affidavit does not disclose the name and details of any of the job card holders. Stop. the Rule 1, Chapter 3 of the Rules of the High Court of Meghalaya, 2013, stipulates that one individual can stipulates that more than one individual can jointly file a single writ petition, on each of them paying court fee payable on such application. Stop. In the present matter, the record does not reveal that that court fee has been paid on behalf of all the job card holders on whose behalf this writ petition has been filed. Give a paragraph. Since the job card holders those who are to be benefited from the outcome of this matter has not been named, and petitioner he himself does not have any cause of action involved there, does not have any grievance to be redressed by the court, more so when the matter is not filed in the form of a PIL, the petitioner does not have any locus standi to pursue the present matter. In absence of payment of proper court fee, this petition is also not maintainable, accordingly this writ petition stand dismissed for want of locus standi and for non-payment of proper court fee. Yes. The matter has been conducted in such a way, even the bona fide of the petitioner becomes questionable. Yes.
Please, Lordship. This matter, Your Lordship. What happened? This petitioner, before filing, after she has approaches in human right also in the forum. Therefore, this court has asked to file the document, the status of the case. What is
this? Is a writ petition.
This writ
petition praying for what?
No, this is regarding the custodial violence. Where the
custodial violence.
Lordship. So
pending from 2018.
Lordship, what happened while filing the petition? The petitioner did not disclose. After some time, he has brought some document, and it seems that she filed some complaint to the human right, and that was still pending. When we inquired,
who filed? The petitioner filed the complaint.
Then that earlier court has asked to file what is the status. Then we filed the application to the human right and to find out whether she has filed it. Then the human rights said either you withdraw. We filed the application for withdrawal at the same time also the certificate copy for.
Why human rights said file an application for withdrawal?
No, we filed, but still yet to be decided. So that is a case pending because that order they have not.
If you have a pending thing before human rights,
This is your lordship.
Yes.
Lordship, can you come to see the order dated 23/6? It appears, Your Lordship, that the petitioner herein has filed a parallel proceeding.
1 minute, 23/6.
23/6, Your Lordship.
There is 23/6.
Yes.
Yes. 7/6 and then 8/7 of
23.
26 2000
of 2023.
2023. This order sheet has become so thick, it becomes quite difficult to find out. It's alright, it should be here. You are also appearing here. Yes, this is there.
Yes, Your Lord. Can you see? Second paragraph. At this juncture, the Land Council for the petition has sought for time to seek instruction in this regard, and if so advised, to file an additional affidavit, bring the said report and other relevant matter not brought earlier before this court to the notice of this court. Another aspect of the matter raised by the respondent herein is that the petitioner may have, in course of the proceeding, approached the Meghalaya Human Rights Commission on the same subject matter. Here too, the Land Council for the petitioner has sought for time to seek instruction on consideration of the submission made the court in the interest of justice would allow the petitioner to take necessary steps in this regard. So, Lordship.
That's why, as per the order, Lordship, I'm pursuing it because I personally went to the human right whether any petition has been filed. They said they have filed it, so therefore I have filed the application to give the report of the status what is going on, and then as per the report from the human right, they said petitioners have abandoned that.
Is it your case that cannot be maintained in two parallel?
Yes.
That is.
So
if you have pending it, why we should go ahead with this?
No, actually, they said that petitioner has abandoned that case. Actually, now we are just. She said that she has withdrawn that case. We are just. We filed the application to give the order status order from the human right.
Withdrawal order?
And this is the application we filed for furnishing a copy of the order passed for withdrawal of that human rights case number 11 of Hitchin.
Why you have withdrawn it from Human Rights Commission?
That's it's a petitioner, no? Because he said
which was filed first. Which was filed first? There in the writ petition or the petition before human rights?
She filed it there, but
which was filed first? Which was
first
filed
was in the human rights.
Then why you have filed
then she has abandoned the case.
Automatically, this is not maintainable. Whether you withdraw it, do not withdraw it. Just for the purpose of making it maintainable, you cannot withdraw it there. And come say now it is maintainable.
Even that
fact remains you approach two authorities at a time.
Even that fact also of filing before the Meghalaya Human Rights Meghalaya State Human Rights Commission has not been disclosed before the writ petition. That has been concealed.
Very, very dangerous. Suppression of material.
Actually,
you have not come with clean hand.
No, that is not actually what happened, because this was actually some NGO was involved. They have filed it. They just take the signature of the petitioner was not aware of those things, and they have filed it, some NGOs, they have filed the on behalf of the, just taking the signature of the petitioner, and she was not aware.
So
And those things
all
was not
factual
there.
aspects. These are all factual aspects. How this court will go and, you see, determine that whether it is correct or not. You may say one thing, they may say another thing. Now the fact remains that there are 2 petitions pending.
Otherwise, Lordship, this inquiry has been conducted by district and session judge as per the order from this court, Your Lordship. The report of the district judge.
At that moment of time, it was not known to the court that there is a proceeding pending before Human Rights Commission.
Correct. No, during the inquiry report, I think that inquiry was detailedly submitted by the district and session judge.
You will do one thing. You will use that inquiry before the Human Rights Commission and make out your case there.
No, but that
use this inquiry.
Inquiry was done. Inquiry was done from the as per the order directed from this court.
No problem. So that is good. There will be more legality attached to it. Now you can say, go and tell the Human Rights Commission that, see, now this inquiry is binding on you.
And then there was a inquiry also from the district, from the deputy commissioner. The deputy commissioner, the magistrate also recommended that there is there was a police custody violence, and he has recommended that some amount of pay has to be paid to the compensation has to be paid to the petitioner. That also was it is inclusive.
That your petition before Human Rights Commission will take care. Why should we pass to different orders?
All these aspects were never brought into regulation. Well, these aspects came into light when you filed a written argument that there was a magisterial inquiry, and then he had approached the Human Rights Commission also. Well, even on merits, this petition.
He has filed a written argument also.
Yes.
So all the matters before this court are all second-hand matters. All are everywhere you will find this has been.
Had the petitioner disclosed the fact of the filing before the Human Rights Commission, the order passed, the High Court would not have passed the order to direct the district and session judge to conduct an inquiry. Because that fact of filing before the Human Rights Commission has been concealed, has been kept, has been...
This is a serious issue if you conceal it, Mr. Sangma. This writ jurisdiction is something, you see, we call it extraordinary jurisdiction.
Lordship,
now it has become most ordinary jurisdiction.
Lordship, I will just check it whether which one is first filed, because I am also not certain, because some document will brought out at a later stage after filing. Actually, there is no intention on the part of the petitioner to conceal the facts.
Best thing will be that you withdraw this thing, pursue your matter before Human Rights Commission.
Lordship,
best thing.
Lordship,
since you have filed it there before approaching this court. See, it is not a case that you approached here first and then you filed here.
Yes.
Then in that case, it would have been different.
No, we will just get only just to ascertain whether, as your Lordship has asked me, whether which one is to, because only that aspect I will. If I have filed the petition.
See, wherever you have filed first, you continue there.
Yes. Suppose if the petition has been filed here first, then I'll continue this.
You do not know.
Because till now, even me also after.
No, but then Mr. Gautam said in your written argument, you said that matter is pending.
I didn't want to hide the fact. That's why after hearing this case only they have brought it the fact, because there also they have there is one order she has abandoned. When I asked the petitioner, she is illiterate, don't know anything. Then she said, how you get the order? It was some notice was issued to him to the police, and he got it, and he was not even aware the petition has been filed by her in the human right. That's why she innocently approached. Otherwise, the matter should have been changed.
My lord, if I may submit, clearly, my lord, this is not a case of custody on merits. No, my lord, what happened was that even this person was arrested, he was found in a drunken position.
No, your lordship.
Then he was arrested, he was detained by the police. On the next day, he was released. Now, after his release, he is a school teacher. He went to his school, he went fishing, he did all his daily work, whatever was required. And then 7 days later, he passed away.
From the district sessions report, it's clearly revealed.
Wait. You will have ample chance.
Lordship.
He was clearly released. He was causing public nuisance, so he was detained. 24 hours he was released. Now 7 days later he passed away. And then they have come up with.
Now that is so far as the merit is concerned. Now what about the issue of maintainability?
clearly when they have approached the Human Rights Commission, my lord, when there is an
Now, if at all there is some proceeding pending there, this court would not like to, you see, like it would basically court would not like to be in any sort of contradiction, all those things. If there are two different authorities, should not pass different things. Plus, it may happen like that you different kind of issue is raised here. You see, here also something different. Then you see, it may result into passing of conflicting orders. So that is what is. It may happen like that. You see, somewhere petition is allowed, or maybe in another authority it is rejected. So. This is why you see, like
Lordship, we will proceed, but only just give me a time just to ascertain which petition has been filed. Otherwise, my lord, regarding the replying to my learned senior was replying in the district session just report, it was clearly case that they even approached the doctor to issue the backdated health certificate. It is on record, your lordship. Page 15 of the report. It's very clearly stated.
All will come.
They have never gone for the medical examination. He was illegally arrested and detained. I have the fact of the case only on the technicality, on the ground of technicality and maintainability. Of course, I agree to that.
Even if you now come and say that this petition before the Human Rights Commission was filed later, then also you'll have to answer why you have filed it after approaching this. You'll be answerable for that.
Lordship, that
over. Take instruction, proper instruction.
Lordship.
Clearly, there is a alternative remedy which he has availed.
That we will do it. I'm just asking for the instruction. I'll decide the future course of action. What can I do? Otherwise,
yes,
I may withdraw.
That is your liberty.
Yes, Lordship.
That is your liberty.
Now it's no point of argument because we have not clear issue of Lordship has pointed out regarding the maintainability. Obviously, I will decide what course of action that I can either I will withdraw
So the
and
question
pursue the matter
of
there.
maintainability is raised by them. The court basically would not like to pass any
Lordship
conflicting order. Okay, if at all this matter is pending before any other authority and a certain order is passed, and as a matter of fact, you cannot maintain, you see, like this
Lordship.
a similar claim before two different authorities. If you have at all the Human Rights Commission, Human Rights Commission will take care. We will not
Lordship.
entertain this writ petition.
Lordship.
Okay. Let him take instruction of what?
Yes, Lordship.
Or you have any specific
No, I don't have any.
Any specific information with regard to the
1 week's time
matter before matter?
He has to file. If he could, although he has to file, then we'll.
No, once I withdraw, then it's no question of filing. Just wanted to ascertain which petition has been filed first. Because I just want
to see you determine it.
Lordship.
Even if you approve some authority later also, you will be answerable for that. Why you approve that authority
Lordship.
later?
Lordship.
Because the
cannot.
Primary relief claimed by the writ petitioner is monetary compensation. So it is not that the State Human Rights Commission does not have that jurisdiction to grant monetary compensation.
Yes, then we can close it. We approve this thing. Pursue the matter there. Let us close it there now.
Lordship.
You will do it.
Okay. I will do that.
And
only
the
with
matter before the
with the liberty to pursue or.
No, the liberty will be there to pursue that matter.
Lordship. Then now I can withdraw this one.
Yes. Mr. P.T. Sangma, Learned Counsel, submits that. You may be allowed to withdraw this matter since the petitioner has already approached the Meghalaya Human Rights Commission.
State Human Rights Commission
with similar prayer. The prayer has not been objected by the Learned Counsel for the respondents. The writ petition stands dismissed on withdrawal with the liberty to
assert for
liberty to pursue or to approach the
liberty to pursue the matter before the
Human Rights
Commission.
Lordship. Much less, Lordship.
Item number 13.
May
Yes.
please, Your Lordship. My Lord, this case pertains to the acquisition.
Very complicated matter.
My lord, this has got a checkered history, my lord.
This court will understand or not?
My lord, I will.
Yes.
But my lord, today at the very outset, my lord, I would like to say is that I'm not ready to do the matter here at full length, my lord. Only thing is that I just wanted to give the little highlight.
You can give it, but
about,
then
yes. Yes, my lord, because there's an affidavit filed by the state respondents objecting to the maintainability of this writ petition. They said it's hit by the principle of res judicata, and also there's a operation of a limitations on me coming forth.
This is a writ petition.
This is a writ petition, my lord. What happened is that
why this plea of res judicata? Okay, I can understand.
Yes.
But then why that plea of limitation?
Limitation in the sense because section I have not availed the benefit of section 18 of the Land Acquisition Act, and then
bypass that.
Bypass that is for them, my lord.
And your primary intention was to overcome that limitation, hurdle put by the limitation.
My lord, it was not an intention, my lord, in such, but that is the plea, my lord. So on the day
these are not views by the court; these are queries.
It is, my lord. So, my lord, on the last date when this matter was heard, His Lordship, my lord, on 27 June 2023.
Heard by this court,
my lord, by Justice Thank You's court, my lord. So this has been transferred here, my lord. Now, so.
Why it has been transferred here? Because of the year of the.
I don't know, my lord. Yes, how is the arrangement? Maybe it's because of the year, my lord. Yes.
Justice Thank You has not recused himself from.
No, not recused himself, my lord. So may I draw, my lord, to 27 June 2023.
Where is that order?
The order.
Order passed in this by this court.
My lord. But Justice Thank You's court, my lord. Order passed by. So
27/3/2023.
27/06/2023, my lord.
See, in all the cases, these order sheets are much more thicker than the writ.
My lord. This is 2019 case, actually.
27/6/2023.
My lord.
Yes.
So, by this order, my lord, I was directed a copy
certificate of registration.
Yes, my lord. Copy of the original certificate of registration and other related documents. Other related documents would mean the proceedings of the meeting of the Kings, my lord.
Why original is needed?
Original was needed because, my lord.
Copy is doubtful.
Not actually doubtful, but what happened was, my lord, along with my writ petition, I have annexed the Xerox copy, because during that time when I was filing this writ petition, the original was lost, and subsequently during the course of it was renewed also, and I have applied for the duplicate copy of the original, my lord. That is, it took 3 weeks to obtain that, my lord. Therefore, 2-3 adjournments were sought. Now the now the registration certificates that has been issued to me is in my possession, my lord, and also the proceedings, my lord, the proceedings of the Kings, my lord. So these documents were sought.
Why this certificate is very important here?
May I just answer that? Look, this the petitioner claims to be a registered association. So a query was put from the court whether, as on the date of filing the case, they were registered or not. What my friend did was he submitted an affidavit. If Lordships will have this affidavit filed on the 22nd of May 23.
Yes.
So, well, as a query of the court was as on the date of filing of the writ petition, whether they were a registered
that is
association.
Law.
What my friend did, they filed an affidavit, And kindly see page 4 of the affidavit.
Yes.
Instead of answering the query with regard to the issue of registration as on 2019, they had themselves renewed. And kindly see the date of renewal, renewed with effect from 13/4/2003, towards the bottom.
Yes. Valid up to 2026. Yes.
23. Now, it says it is valid up to 12/4/2026. So it appears any of these certificates that are issued, they're only valid for a period of 3 years. So the court again made a query as to what was your status as on 2009, which is the date of filing of the writ petition. That has not been answered as yet. And as far as the second
affidavit does not take care of the query which was made.
It does not take care of the query. There is a second query, Lords. Kindly see the writ petition. While the writ petition is filed by the, if your Lordship sees the cause title of the writ petition, the cause title is at page 2.
Yes.
Let's kindly see page 2. The name of the petition, the details of the petitioner. It says Balpakram Aking Nokma Social Welfare Association, represented by its attorney, Srimati Ruthila R. Marak. Now that power of attorney is at annexure 1, page 9 of the writ petition.
Not by President, Secretary or anyone.
No. So the question was, why was this arrangement entered into in the first place? Now Lordships will find
page 9. Yes.
Kindly see page 11 of this power of attorney. One of the stipulations was found to be suspicious by this honorable court.
Yes.
Clause 5. It reads that after the land compensation and or enhancement of the compensation, solatium, interest, etc. is done, we agree to issue the checks duly signed by us to our attorney as their share before we withdraw the remaining amounts as stated in our earlier individual deed of agreement dated 16th June 2012. The court found these are all public monies. And there appears to be some sort of a financial arrangement between the attorney and the principal. Now, we don't know what this matter is all about. So, which is why the court wanted to examine this particular agreement dated 16th June 2012.
There also the bona fide of the petitioner comes.
Precisely. Well, they have continuously said that the Akings are illiterate people. They have no knowledge of what is going on. As such, they have not been able to pursue this matter. But it turns out this arrangement has become a subject matter of question before this court.
Now, this power of attorney has been executed by whom?
By, can you see?
The secretary, my lord.
The page number 12. It has been signed by the president and secretary of this association.
Can they do it?
It is the MOU, if I understand, the articles of association will indicate it that they should be sued. Or
can president and secretary authorize an attorney, engage a power of attorney holder?
No,
normally,
ideally they have the right to do it. It is already an association. It is usually the secretary or the president.
Association, there must be a resolution by the association authorizing the president and secretary.
So, which is why
and
they were required to file an affidavit bringing this particular agreement of 16 June on record for the court to examine it and to examine the bona fide.
The 16 June means which one?
Page 11 is the power of attorney. That stipulation, the clause number 5.
Yes.
So this refers to an earlier individual deed.
This is dated 11/5/2017, I think.
So the power of attorney, my lord, is dated.
The next page, page 12 gives
11/5/2017. This is the date of the power of attorney.
And then the agreement which was referred to in.
This is at clause 5, page 11.
So that was not brought into record.
That has not been brought on record till today. And also the status of the registration as on 2019 when they filed this case.
My lord, that is what I need to answer, my lord. My lord, two things those are the queries of my lords. My lord. So the first query, my lord, what was my status when at the time of filing of this writ petition, my lord, whether I was a registered association or not, my lord. So the registration copy, my lord, which I stand by my submission still today, my lord. The registration certificate, my lord, which was issued to me by the sub-registrar, my lord, of societies, my lord, does not mention the expiry date, my lord. That is the reason why, my lord.
What is that certificate? Which certificate you are referring? The certificate which Mr. Sen has pointed out just now.
Not that one, my lord. That is a renewed one, my lord. That was a renewed one.
Other one. Other was in part of record.
No, it is not in part of
that is here. That is the reason why, my lord. That was initially at the very
See,
first
if you
steps.
have to argue based on some written documents, the other side must have the copy of that.
My lord, exactly. That's why, my lord,
because the genuinity of that
Yes.
has to be.
Yes, my lord. So now, my lord, to think the certificate, the initial certificate, because now I have duplicate. I'm in possession of the duplicate, my lord. Is issued by the, and also the resolutions, my lord, authorizing the secretary and the president secretary to appoint an attorney, because, my lord, those resolutions needs to be brought, because those are the queries from my lord. So
the normal thing is that, you see, normally the association authorizes either its president or secretary.
President or secretary.
Now they themselves are authorized person. Now whether the authorized person will have the authority to engage another.
My lord, there is a resolution.
Delegate their authority to somebody
also
else.
for consideration. That is the most important aspect. It is for consideration.
My lord, once my lord goes through, when I pointed out the resolutions.
And then how you will deal with this clause 5 of the power of attorney?
My lord, that will be dealt by the resolutions of the members of the Aking, my lord. Let me bring on record this one, my lord, because right now nothing is before my lord. It's only in my possession.
Any authority is made,
my lord. Yes, my lord.
On the basis of some negotiation, whether that authority will be legal.
My lord, this authority, my lord, is subsequent to the resolutions of all the members, my lord. This authority, my lord, it's not preceding, my lord. It is not post. First you make an attorney, then you go for a resolution. It's not a case, my lord. First the resolution was made.
Now, that is okay, but then what about the stipulation in paragraph 5?
Paragraph, my lord, I will answer to that one, my lord. Let me bring on record this first, my lord, just 1 week time. I'll bring on record. We will all have the papers, my lord. Then I can try to persuade, my lord. Because what happened here is, my lord, the illiterate villagers have been divested of their traditional lands, my lord, by paying a meager money, my lord. So till now, my lord, that the violation of their rights, my lord, till now keeps on. It's continued, my lord. Their violation of the right keeps on continued, my lord. That is where we have been educated. And there was also a subsequent to the writ petitions, my lord. And there was a reassessment also done by the deputy commissioner, my lord. And the reassessment says that yes, they have been underpaid. So, my lord, all this, I know I have a Herculean task to overcome all this.
The reassessment says that they are underpaid.
My lord. And they
can it be taken into consideration by this court to enhance the compensation?
That's a new course of action, my lord. And my representation,
no, the writ court basically.
Yes.
Do you expect the writ court to do it?
My lord will examine.
If say law itself provides.
My lord, but my lord will examine whether I have been deprived of my legitimate award, legitimate right to compensation or not.
But then the provision in the act takes care of that.
My lord,
when it comes to determination of amount.
Yes, my lord.
The provision in the act is there. Why this writ court should assess? If you are not provided that opportunity, which is provided in the act, then writ court may. But then otherwise not.
My lord, 3 representations were filed, and this court has also directed to dispose of my representation with a speaking order, my lord.
This representation has not been.
It has disposed of with a speaking order, and in the speaking order itself, they says that they have admitted, yes, they have been underpaid. They were supposed to be paid certain amount.
You use it as evidence before appropriate authority.
But they will not accept that, my lord. They will not accept that because what they're saying that
that will come as evidence. Why they will not accept it?
Because what they're saying is, my lord, we are sorry, you are too late in the day. So that representation, my lord, in order to do a substantive justice, the Guwahati High Court in the Dickman's case, my lord, says that this representation could have been converted into a into an application under section 18, my lord. In a Digman's case, my lord.
This could have been, not should have been.
Should have, and it was also, my lord.
But I think the antecedent fact is more to kindly just turn to, I'll make this very clear, kindly turn to page 13 of the writ petition. There is an order of the Guwahati High Court.
Page 13 of the writ petition.
Page 13 of the writ petition.
WPC number 315.
Lordship will find in
Yes.
the court title itself, there's 315, 75 and 152. So there were a total of 5
There also the
petitions.
petitioner is the same.
Yes.
But then represented by secretary.
My lord.
Correct. So there's been some sort of a transaction between them, which has some consideration involved. So there were 5 writ petitions which were disposed of by this one single judgment dated 2nd of March 2011. Now, kindly have page 16, 16.
I have not appeared for any of the parties
No,
in this case.
I'm not aware. I don't suppose your lordships have appeared. No.
This is of 2011, my lord. I don't know.
So name of Mr. E.B. Sangma, advocate here, so that is why. Anyway, I don't remember.
No, my lord. It's
Let's read, my lords, at page 16.
Yes.
16.
Yes.
This batch of writ petitions arising out of the alleged taking over of Aking lands for the purpose of Balpakram National Park in the Garo Hills Autonomous District Council, with the consent of the councils appearing for all the parties, are taken up together for hearing and are being disposed of today by a common judgment.
Yes.
Now this line in para 2, the introductory line, is very important. In WPC number 315 SH of 2002, the petitioner is an association. So para 2 onwards only deals with WPC 315 SH of 2002. The petitioner is an association of Dokmas of the Aking lands situated in Garo Hills, Meghalaya, and is registered under the Society's Registration Act of so-and-so, White Registration Certificate number 29/2002. In the year 1985-86, the state government, for the purpose of setting up Balpakram National Park, proposed to acquire the said Aking lands in several phases. In the first phase, 10 Aking lands with an estimated area of 220 square kilometers were acquired at the cost of 3.63 crores at 1.65 lakhs per square kilometer. Again, in the year 91-92, another area of Aking land estimated to be 76.25 square kilometers was acquired at the cost of 1.26 crores at 1.65 lakhs per square kilometers. Thereafter, in the year 94, an additional Aking land of 15.5 square kilometers was acquired at the cost of 25.69 lakhs and was handed over to the Forest Department on 19/4/94. Again, in the following year, that is 1995, another Aking land measuring 39.91 square kilometers was acquired for 65.85 lakhs as 1.65 lakh per square kilometer. In this manner, a total of 352 square kilometers has been acquired till 95-96. However, in the year 96, an additional Aking land measuring 114.85 square kilometers was sought to be acquired from 8 Akings for the purpose of expansion of the park. It is the case of the petitioner that except for this 114.85 square kilometer of land, no proper land acquisition proceedings were initiated apart from issuing notifications purportedly under section 4 and 6 of the Land Acquisition Act, and that the unsuspecting illiterate Nokmas were made to sign on blank papers which were made out to be agreements. They were never informed of their right to receive money under protest or their entitlement to higher compensation in the absence of adequate compensation. Moreover, according to the petitioner, in assessing the rate of compensation, the respondents totally ignored the rate fixed by the GHADC and paid them 1.65 lakhs per square kilometer, which worked out to be a mere 200 rupees per bigha. While determining the quantum of compensation, the value of standing crops, trees, mineral deposits, etc. were not taken into consideration. Solatium was also not paid, ignoring the provisions of the Act. Now, from their own pleadings of the petitioner, it becomes obvious that the landowners represented by it were aggrieved by the quantum of compensation awarded to them between 91-92 and 95-96. In my opinion, it is now too late in the day to challenge the award made some 7 to 15 years before. Moreover, if the petitioner is really aggrieved by the quantum of compensation so awarded, it had the remedy under section 18 of the Act for reference by the collector to the Land Acquisition Court, provided that it was filed within the period of limitation prescribed thereunder. Having not done so, the writ petition insofar as 352 square kilometers is concerned is barred by non-exhaustion of an alternative statutory remedy. As for 114.85 square kilometers of Aking land, the state respondents at para 11 of their affidavit in opposition dated 11/12/2002 have clearly stated that this additional land comprising of 8 Akings is yet to be acquired. This position is reiterated by them in para 10 of their latest affidavit in opposition dated 18/8/2010. It is also categorically asserted by them in paragraph 19 therein that the Forest Department does not occupy or use any of the aforesaid land and will not do so until the same is properly acquired and handed over to them by the district collector. This is reaffirmed by the Chief Conservator of Forest Government of Meghalaya in his affidavit dated 10/9/2010. In the light of the categorical declaration made by the state respondents that they are yet to acquire the Aking land measuring 114.85 square kilometer, no mandamus can be issued by this court for directing them to pay the compensation. To this extent, the writ petition appears to be premature. It shall, however, be open to the petitioner to approach this court again if the state respondents decide to take over possession of the Aking land in question without payment of compensation or without following the procedures laid down by the Act. However, the state respondents shall not occupy or otherwise take over possession of any portion of the Aking land measuring 114.85 square kilometer before payment of due compensation to the petitioner association or without authority of law order accordingly. This ends insofar as 315 of 2002 is concerned, that writ petition. Thereafter, the court goes on to discuss other writ petitions and make certain observations that they could file an application under section 18 before the reference court.
The other petitions, they are not.
No, they have been foreclosed.
They are confined to 315.
Lordship. So their remedy under section 18 has been foreclosed by the observations made in this judgment. Now, pursuant to this, what they went on to, they filed successive number of representations before the chief secretary.
What about that part? 115.
That is not the subject matter of dispute. That is not even sought to be acquired.
It is not been acquired till date.
Till date.
So then there remains no cause of action.
There remains no. Now his case is that they have filed successive representations before the authorities, the chief minister and so on and so forth, and they say that that has built up into a new cause of action because at some point the law department issued some sort of, they conducted a reassessment and said that they were underpaid and should have been paid according to the rates determined by the GHTC. Now, Lordships are aware, this was decided in the case of Modi Sangha, that the GHTC does not have the power to determine rates for the purpose of land acquisition.
Well,
that is the sole domain of the DC. So
you are holding that decision with you.
Lordship.
You are holding that decision with you.
At the moment, Lordship, I have this.
That the district council has no authority to fix it.
No authority. No authority. So now, I think his case is premised on these successive representations that were filed, and he claims a new cause of action has been formulated somehow. And thereafter, they came before this honourable court in a writ petition and said that one of the representations had not been disposed of. This court merely gave a direction that the concerned authority should dispose of the representation. That is all. Now, their requests were rejected. On the basis of that, again, they claim there's a new cause of action altogether. Now, statutorily, the remedy lies under section 18. The writ court cannot decide the compensation. It has not been quantified till today. Who's going to carry out the quantification?
No, you see,
and the right is foreclosed.
If entire matter falls under the purview of Land Acquisition Act.
Precisely.
Okay, and all the the related procedures have been followed.
Lordship.
And matter comes to an end.
Lordship.
By a judicial verdict of the court. I think this judgment has not been challenged anywhere.
Till date, this
so it has attained finality.
Lordship.
Now, can an executive action reopen the issues which are settled?
And they cannot. They cannot. See, and moreover, that was merely an observation.
The judicial finding will always stand superior to whatever the executive is.
Absolutely.
If it concerns the whole, if it operates in the same field, that is it. Anyway, so
even without going into the issue of the registration, this is sufficient, my lords, my humble submission.
Now you see, you'll find what he can do now. Now you have taken to court to one aspect, now you will take the court.
And my lords will kindly see the order sheet. This was filed in 2019. From 2019, innumerous number of dates have passed where even the matter did not see the stage of motion. Kindly see the order sheet from 2019 onwards. No, there was motion, it went on to admission and so on. I have not filed an affidavit on the merits of the case because I had all the while challenged the maintainability of this petition.
You do not intend to file any affidavit?
Lordship, there is nothing to respond to this. It is not maintainable at all because there is an order of...
So far as this part is concerned, this court is... My lord. Of course, Mr. Yobin's part is there. Lord. But then your submission seems quite convincing.
Lord.
Okay. My lord, when we relooked into the judgment which my friend has just referred, my lord, it will go to show, my lord, it will go to show that this court has not closed the door for me, my lord. has
In
left a
respect-
window
only
open for me.
only in respect of 114.85 square.
114.58, my lord, that has not been acquired.
So, but then so far as the other things are concerned, that is closed. Why not?
My lord, kindly look at was it barred for what, my lord? The order itself says, having not done so, the writ petition insofar as 352 square kilometers is concerned is barred by non-exhaustion of alternative statutory remedy. It's barred by non-exhaustion. Non-exhaustion means I have not gone, I have not applied, I have not filed under section 18.
Yes.
Which means, my lord, it's per se not completely barred because I still have a remedy. I still have a remedy, my lord. When, my lord, and it is been admitted, my lord, it is admitted that the acquisition itself was irregular, my lord. There was a contention made. But then what did the court say? The court says that no, sorry, you have not approached, so you are barred. You cannot raise now.
It is basically the law of limitation also will have the limitation, not law of limitation, the limitation prescribed in the act. That will make these things. The issue, you are barred from doing these things because you have not raised it within the period of limitation.
My lord.
And that is what exactly has been held by the court in the earlier round of litigation.
My lord.
So it is barred.
My lord. So, my lord, can we take it some other day? We will try to.
That is all right. We can,
my lord, I understand quite.
We can do it, but then it is you have like a tough job.
My lord, I understand, my lord.
The objection raised by.
My lord, I understand, my lord. But my lord, I'll try to persuade my lord.
Because apparently it seems
my
it's quite convincing what the state says.
Yeah, my lord. I will try to I'll try to persuade my lord. When I know I'll go down fighting, but
no, there is no question, Mr. Yubin. This court also will be interested to see how you make out case.
My lord, give me 2 weeks time, my lord. I'll come back, my lord. With because this concerns, my lord, a traditional land, my lord. On the face, everybody has agreed to one thing. That the underpaid, the gullible villagers have been underpaid. Somewhere they have been victim of, so to say, my lord, states arbitrariness in paying fairly to them, my lord. Of course, I'm not into that district council. They should have been paid the amount of district council or not district council, my lord. That is not. At the end of the day, my lord, who has to decide?
See, you have to take care of two parts. Your locus standi also just remember. Not only with regard to the cause of action, which Mr. Shan has pointed just now. The first part of the argument, your locus standi.
My lord.
That also you have to satisfy the court.
My lord.
Because you are here appearing here as an attorney.
My lord.
Attorney holder.
My lord.
So that is what also this court has.
My lord.
Some doubt whether.
My lord, 2 weeks time I'll try, my lord. Otherwise, I will.
Yes, Mr. Shen, 2
weeks. Honorably, I might surrender also.
No,
but I'll try my best, my lord.
See, Mr. Yubin, your research is learning for the court also.
My lord.
So that is what the court will always look for those. Able assistance makes.
My lord.
And you see, enlightens the court.
And this application method, the original certificates that my lord has sought, should I bring it in the form of affidavit? Or
no, this is it's by a judicial order, so you have to.
My lord, I'll do.
You will be bound by that.
My lord,
the certificate as well as the other agreement.
Agreements.
Yes,
it is there.
But then that clause 5 also you have to explain.
My lord, it is
how
there,
you can appoint an attorney on the basis of payment.
My lord, let me bring the papers.
It's a commercial deal.
It's a commercial deal. That is the suspicion.
My lord.
Reed court will definitely take care of this. And this court is very strict with those kind of
my lord, I bow down to that, my lord. Nobody should be allowed to play with the judicial system or the legal system.
Just now also, just sometimes back, probably one matter, Mr. P.K. Bora was appearing.
My lord.
I do not know whether cause was genuine, but the manner it has been done. See, this court is not at all satisfied.
My lord.
So, that is something.
Yes.
We must come with clean hand, you see.
My lord.
Anyway, Mr. P. Even learned counsel for the petitioner. 6 further 2 weeks time for What is that production of? Original of what?
Original of the registration certificate.
As on the date of filing of the writ petition. 2019.
2019.
The production of documents.
Production of documents.
As required by this court order dated 27/6/2023.
My lord.
Just tell me, Bishop.
The original request was 2022.
As required by this court's order dated 27/6/2023. Mr. Sen, Learned Senior G, has no objection. Prayer allowed, list after 2 weeks.
Obliged.
Item number 40.
Yes, Mr. Sinkan.
My lord, this is a second round of litigation, my lord.
Why? First round was not satisfying.
No, my lord, that is that is why I had to come again, my lord.
Your synopsis seems to be longer than the writ petition.
My lord. My lord, if I can explain briefly about the case, my lord.
Yes.
My lord, petitioner, my lord, he was appointed as technical assistant since the year 2013 at Negrims in pursuance to an advertisement dated 1st October 2012. So
this appointment thing is enclosed?
Yes, my lord, that is at Annex 1, page number 15.
Yes, give me the facts.
That is the advertisement, and the appointment order is at next page, that is page number 17. That is his appointment order. We will just page number 17, my lord. It says
that is Annex 1 is the advertisement.
Advertisement, my lord. This is the appointment order, page number 17. It says
you responded to this. You responded to that.
Yes.
Advertisement.
Yes, my lord.
And there was a selection process there.
Right, my lord. And I was appointed as the technical assistant. It says, the order says on the
approval for 6 months.
My lord, it was for 6 months, and there was
this advertisement also was for that, was it?
Yes.
What the advertisement stipulates? Was it mentioned that it is for, it will be on contract basis?
My lord, advertisement is at page number 15. It says vacancy in Negrims of technical assistant and other vacancy, Northeastern Indira Gandhi Regional Institute of Health and Medical Sciences is going to conduct a walk-in interview for filling up
so
the
it was
vacancy.
not a proper recruitment probably.
Yes.
Walk-in interview.
Yes, from energetic and through the notification number so and so. That's why interested aspirant may be appear in the interview on scheduled date and time. Recruitment related more details can be seen below. So this is the number one.
It doesn't mention the period for which. But then it is walk-on interview.
Yes. Now thereafter, my lord, I appeared in that interview and then I was successful, and thereafter I was issued a appointment order. The appointment order says, my lord, on the approval of the director, Northeastern Indira Gandhi Regional Institute of Health and Medical Science, Shillong, is pleased to appoint Sri so-and-so as technical assistant on contract basis for a period of 6 months with effect from the date of joining. And thereafter, my lord, in the next page, page number 18, I have joined my service.
20th March 2013.
My lord. And subsequently, my lord, my service was extended. That is at page number 20, type copy, my lord. Page number 20. This is type copy. Subsequently, the service of the petitioner along with other employees, my lord, these were extended from time to time, and I continued in service. Now, what has happened?
Your serial number? Your name appears at serial number?
My lord, I'll just find out. 11, my lord. Page number 21.
Your Jet Lang? Rinja.
Yazid Lang Rinja, page 11. Now,
yes.
After that, my lord, the
This
service was extended from time to time.
From 46 to 36.
Yes, and thereafter, my lord, subsequently
It was for around 25-26 days.
Yes, and from time to time, my lord, the service was extended. Then, my lord, what has happened is on 2nd July 2019, I was in my service only. I was continuing in my service since 2013. And on 2nd July 2019, my lord, they have issued a letter saying that the employees who were earlier appointed on contract basis in the institute shall be engaged through outsourcing under the terms and contract of the present contract. That is at page number annexure 5, my lord. Page number 22.
Annexure 4 is what? This is a representation by you.
Annexure 4 is yes,
yes,
that is the representation for regularizing my service.
Yes, okay.
Now,
yes,
page number 22.
Yes.
It says, with reference to the subject cited above and on approval of the Director Nigrams, I am to inform that the following employee who were earlier appointed on contract basis in the institute shall be engaged through outsourcing under the terms and conditions of the present contract. In this regard, it is requested to appoint the said employee as per list enclosed through outsourcing on temporary basis.
So, and through outsourcing means you are already there in service.
I am already there in service. Then, now what they want, I was on a contractual basis, and thereafter they wanted these employees who are already serving to be engaged through outsourcing process, my lord. And my in that list
it says that requested to appoint the said employees.
Yes.
Through outsourcing on temporary basis.
Yes. That is where my grievance is, my lord. And my number in the list is.
Now, if you are in service, then you are taken out again.
Yes.
And through somebody, then you are brought in again.
Yes. And that is my number at the next page. In the next page, my lord, page number 23, my number is at page number, serial number 11.
It is not a case that you have been discontinued?
No. They said to engage it through outsourcing process. Now, what the law says in this aspect, my lord?
Okay, now you are aggrieved by this.
Yes. Now, no, my lord, there are many other things also.
So then what happened? This is in 2019.
Yes,
then?
my lord. Now, as far as the outsourcing of employees, where it involves the technical assistant is concerned, there is already a law which has been laid down by the courts, which says it cannot be done by outsourcing. My lord, if I can take your lordship to page number 4 of my petition.
Your facts part is over.
No, my lord, I will come slowly. Why I am going, my lord, because otherwise it will mix up. Page number 4.
Yes.
Here, my lord, I am referring to one of the judgment, my lord, at paragraph 4. Here I said, my lord, that the petitioner states that the Honorable Supreme Court in various cases has observed that the power of a state as an employer is more limited than that of private employer, in as much as it is subjected to constitutional limitations and cannot be exercised arbitrarily. Here, my lord, I have referred to a judgment of the Andhra Pradesh High Court. Here it says, this judgment, my lord, Basaveshwara Rao versus Government of Andhra Pradesh.
Single bench or division bench judgment?
This is.
Anyway, it's okay. Carry on,
yes,
carry on,
yes,
carry on.
the fact of the case, my lord, it says, wherein, my lord, the questions which came for consideration is whether the functions of the technical staff in government hospital can be outsourced by requisitioning the employees.
Where are you reading from? Which?
Now, my lord, in the same page, my lord, page number 4, last portion. It says, my lord, the same question came to be considered, my lord, there in that case.
Yes, carry on.
Wherein the question which came for consideration is whether the functions of the technical staff in government hospital can be outsourced by requisitioning the employees through outsourcing agency. And the Honorable Court has held that since there is no challenge in the present batch of writ petitions to the said government order and the present issue related to the engagement of service of certain persons through outsourcing method in the medical and health department, this court purposely refrained from expressing its view on the validity of the above state government order, but confines its examinations of entrusting the duties of nursing and technical staff in the government hospital through outsourcing method. Now it is well established that the right to life and personal liberty enshrined in Article 21 includes the right to health. In so-and-so cases, the Honorable Supreme Court referred to Article 47 in Part 4 of the Constitution, which reads as follows. Duties of the state to raise the level of nutrition and the standard of living and to improve public health. The state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties, and in particular the state shall endeavour to bring about prohibition of the consumption except for medical purposes of intoxicating drinks and of drugs which are injurious to health. After referring to the said article, it held that the maintenance and improvement of public health have to rank high in the obligations of the state, as these are indispensable to the very existence of the community, and on the betterment of this depends the building of the society of which constitution maker envisaged. The maintenance and improvement of public health naturally include employment of right people for the right job. Though the district authorities may insist upon qualifications for the persons requisitioned through outsourcing method, it may not ensure the effective discharge of duties by such people. Mere discharge of duties is not enough, and it should be effective. In order to be effective, one has to gain experience through long years of service. Advocacy cannot be encouraged where medical care is required. The people employed in such fields should have security of employment and proper condition of service. The absence of these requirements may lead to unhealthy practice by such person, which may result in negligence of duties and fleecing of poor people in the society. Article 43 of the Constitution of India in Part 4 is also relevant in relation to employees recruited. The said article reads as follows. Now, my lord, the very important
These are all directive principle of state policy.
Yes, my lord. Now,
is it enforceable in a court of law?
But always endeavor has to be made to achieve that goal, my lord. Now, what the court says, it also speaks about Article 21. If my lord will come to the next page number 6.
What the ultimately this decision?
Yes, that is where I'm coming. Page number 6.
Yes.
If there is some dots, my lord, I have given, and then I started with, in view of this situation,
yes,
it is hereby held that the service of nursing staff and paramedical staff in the government hospital cannot be outsourced, as it is contrary to Article 21 of the Constitution of India, and the service rules applicable to the services. Now here, the court.
See, and the service rules applicable.
Yes, that is another aspect.
Here,
we are only concerned up to Article 21.
Just 1 minute,
my lord.
Do they have any sorts of service rule? The authority concerned, which empowers them to outsource?
No, my lord. No.
Okay.
Here we are only concerned up to Article 21, my lord. This violates Article 21, such actions of the hospital, my lord. Now, on the basis of this, my lord, what I have done, I have approached this honorable court by, if my lord will come to page number 7. I have approached this honorable court by WPC 253 of 2019, challenging that order dated 2nd July 2019, whereby they said they want to engage through outsourcing. I have challenged that order. And the honorable court, my lord, by dated 15/7/2019 has passed an order. It says, by it has disposed of the writ petitions wide order dated such and such by permitting the petitioner to file a comprehensive representation by incorporating the claim as has been raised in the writ petition within 15 days from the date of receipt of the copy of the order before the respondent who is arraigned in this petition, in this case as respondent number 4. And further, it was directed that in case such representation is filed, the same shall be decided by the said respondent after affording opportunity of hearing to the petitioner as well as to the respondent number 7. In this instant case, by passing a speaking order within next 6 weeks in accordance with law. Thereafter, my lord, I have filed my representation on 30/7/2019 before the respondent number 4. And my lord, here in this same paragraph, I have also stated, it is to be stated herein that the respondent number 4 did not comply with the order dated so and so 15/7/2019 passed by this Honorable High Court in WPC number so and so, and to utmost shock and petitioner have received an order dated 3rd September 2019, releasing him from service with effect from 30th June 2019. Instead of complying the order of the court, my lord, what they have given me, they have given me.
They throw you out from the service.
Yes, they have thrown me out from the service.
That is natural. That is what happens.
Yes. So, being aggrieved, my lord, I have challenged this order dated 3rd September 2019, my lord, in this petition, my lord. That is absolutely illegal.
You're ousted from service.
Yes, my lord. And if my lord will see the affidavit which has
now, the representation which you filed,
my lord,
in pursuant to the order passed by this court,
right?
Whether that was replied,
yes,
was it?
I'm coming to that, my lord. If my lord will see the affidavit filed,
now you're ousted from service,
right,
before the reply came, or the reply came after.
Yes, yes, if my lord will see the affidavit,
yes,
which has been filed by the negligence, my lord.
Yes. Now, so far as your writ petition is concerned, now only up to this much, that
right,
till your,
yes,
that is the factual aspect.
Yes,
rest are your submissions.
Factual aspect. And as far as the order, compliance of the order, my lord, that was to be complied within 6 weeks. The order now that order was on 15/7/2019. I filed my representation on 30/7/2019, within time which was.
Now they have responded to it.
Yes, they have responded. But if my lord will see Annexure 1, that is in.
Now they have what is their, now your challenge is only against your ouster, or
yes,
or you have further relief.
No, my
you
lord.
Claim for further relief.
My
3rd September. Where is the order of your impugn order?
Yes, if my lord will see the affidavit filed by the
your this in your writ petition, you have not enclosed.
Yes, I have. My impugn order is at page number 37, my lord.
Yes, that is completion of the contract.
Yes. So, my lord, the court said otherwise.
That is not that, you see, the court said for representation. Now, why you are connecting that part? Your continuation service.
If my lord will see.
Now, after this
order was passed on 3rd September 2019.
Yes.
And they are releasing me from service with effect from 30th June 2019, from back date.
No, on that day your contract expired.
But I am still in service, my lord. That when this order was passed, 3rd September 2019, they have released me because of all these court cases.
No, you see,
when the matter is pending.
I can understand, you see, but then there are many things. You see, the law is something else. You see, like if you have to show that there is a malafide.
Yes. Now,
had there been a discontinuation during the subsistence of contract, we could have filed it. Yes, that is malafide. But in here, there is not a disputed fact that your contract had expired, isn't it?
Yes. Now
that in that such a situation, it would be difficult to give it a different color.
My only grievance is that is I understood what my lord is saying.
Lawyer,
yes. Right,
Mr. Singham.
Yes.
You must be knowing those parts.
Yes, my lord. My lord is very right. What my lord has stated is my contract has expired, and therefore they have removed you from service.
So your challenge is only confined to your removal.
Yes, my challenge is only regarding this order. And another my submission is that ad hoc employee cannot be removed by appointing another ad hoc employees. Now here they are trying to engage somebody by way of outsourcing method. That is also an ad hoc appointment, my lord. An ad hoc that is the law, my lord. Ad hoc employee cannot be replaced by another ad hoc employees.
No, but then their opportunity remains for you also. You can also be again taken back through that outsourcing.
And now, my lord, as far as the order which was passed by this court.
Now, removal of ad hoc by another ad hoc, if it is immediate. Say supposing you have been removed. and then immediately somebody has taken it.
Yes.
Now there you can say that is a removal of ad hoc by another ad hoc. What happens, say supposing you were there as ad hoc and then your term comes to an end and there remains a gap of few months and subsequently somebody else is again taken on ad hoc basis. You said this is a removal of ad hoc by another ad hoc.
Now, my lord, exactly the same thing has happened here, because
removal is something, you see, which would come when you are continuing a certain position. But then at the end of...
No, it is not at the end, my lord. My lord, what has happened is, as per this order also, my service has expired on 30th June 2019. They have issued me this order 3rd September 2019. Means I was in
They were happy with you.
I was allowed to continue with my service, my lord.
They have
Beyond
made
the
you
period
continue. Did they pay you for overstay?
Yes, they
have paid you.
As far as my salary is concerned, my lord, I am.
But then what right you to confer in favor of you? Your continuation for few days beyond the term of the contract, would it mean that your contract stands extended automatically? What would be the position of law? Show any law which
when
says...
they have, my lord, when they have allowed me to continue with my service beyond the period of contract, my lord, it means my service has automatically been extended.
Show us some law.
Yes, my lord, I do not have as on today the relevant decision, but if my lord will see the affidavit which has been filed by the Nigrims, my lord, the respondent, here they have issued me show cause notice on 1st day of October 2019.
What for show cause?
To reply, my lord. That is because
no,
after the order was passed by the in the earlier litigation, my lord, in when I challenged that outsourcing method,
yes,
then that order was given that you go and file a representation. I filed the representation, and after I filed the representation, the court also said that you should give an opportunity to the petitioner. Then they did not give me. They gave me only on 1st October 2019. 1st October 2019, whereas the order of the court was 15/7/2019, and court said to decide within 6 weeks. August and mid-September, the time already expired. However, in the month of December, 1st October 2019, they have given me this to reply. Whereas
that is in accordance with the order of the High Court.
Right.
You needed reply means what? You have filed your representation. Then
yes, I filed my representation.
It was up to them to decide that.
And then they have decided against me that I am not entitled to be continued in the service.
No, that is okay. But then what about your representation was against outsourcing?
Yes, it was against outsourcing.
It was not for your regularization of the service or...
My prayer was there.
No, but then your earlier round of litigation is what? Then you see,
my lord will see.
This court was made to understand that your earlier round of litigation and the order passed therein was confined to the issue of filing of representation by you and disposal of the same by the authority, respondent authority.
Right. What was
concerning the outsourcing?
Outsourcing, and I have prayed for regularization of my service also in that.
Was it this thing order passed by? Where is the earlier order passed by? Earlier order passed by?
It is there, my lord.
Please tell us to what.
My lord, that is at page number 25.
Try to stretch the direction, whatever.
Page number 25, my lord. Relevant paragraph is page next page, my lord, 26, paragraph 5. It says, after hearing learned counsel for the parties and pursuing the writ petition without expressing any opinion of the merit of the controversy, the writ petition is disposed of at this stage by permitting petitioner to file a comprehensive representation by incorporating the claim as has been raised in the writ petition within 15 days from the date of receipt of the copy of this order before respondent number 3. it is directed that in case such representation is filed before the respondent, the same shall be decided by the said respondent after affording opportunity of hearing to the petitioner as well as to respondent number 5, who is also an interested party, by passing a speaking order within next weeks in accordance with law.
Now, what was your thing? Did it claim in the writ petition? What was your claim in the writ petition in that?
I'm just trying to find out.
In that case, your writ petition is a part of this.
My lord, it is not part of this.
Now, thereafter, where is your representation? Where is your
the next page, my lord, 27.
Yes. What do you say in your representation? You cited that same decision which you are relying on now.
Right, my lord.
And then what is the...
And last page 36, my lord.
Request part.
36.
So your prayer was confined to your regularization.
Right, yes, my lord. And equal pay for equal work.
You filed quite a long representation, isn't it?
My lord,
yes.
The same judgment which
the last page is 36, is it?
Page number 36, my lord.
Yes. Now the last part is your
prayer.
The light of the it was a side post on regular basis. It is humbly prayed the service and maybe can be regularized. Now these posts are all what? These are temporary posts or what?
My lord, there is already a vacancy, my lord.
Right from the inception, is it something like that they go on engaging people on contract?
They have engaged through our contract basis, my lord. Whereas these
are not permanent vacancies.
Permanent post otherwise.
Subsequently,
no, it has been advertised now. It's been a regular selection has been done.
In case, my lord, if
now in the regular selection has been done, you have not participated.
My lord,
if you have not done, then what remains for you?
Once these posts are, my lord, filled in by a regular advertisement, my lord, then, my lord, in that case, of course, I do not have any further.
No, that is what the submission of the.
But whether this has been filled in by a regular advertisement, my lord, that is it is.
Because the affidavit was filed last year, my lord. And advertisement was issued to be annexed along with our affidavit, my lord.
No, if you are you have already initiated process for regular selection, then there should not be any grievance remaining. You see.
It's not. Whether this has been filled in, if learned senior can throw a light. If
Annexure 3, page 11, my affidavit, my lord. Respondents 1 to 6. Filed in the month of May 22.
4th of May.
4th of May. Page 11, Annexure 3, my lord. This is the advertisement.
Page what?
Page 11, Annexure 3.
Yes.
This is a very comprehensive advertisement, my lord. Nursing of staff 231.
What is the post held by?
Here is a technical assistant anatomy, my lord. That you lots of will see at page 13, my lord. At serial number 4.
Page
13.
Page 13. No, page 13.
But the
anatomy
department of anatomy 1 post.
No, that is page 13 is the continuation of technical assistant. Yes, yes. It starts from here.
This is the post.
Yes, serial 7, isn't it? Technical assistant, and then we come to page 14.
Yes, my lord. Your technical assistant is in different departments, so he belongs to anatomy department, my lord. This post has been advertised.
Yes, Mr. Singhon, then what remains?
My main grievance was that they were trying to fill in through outsourcing process, which is not permissible as per law.
Now it is gone.
Yes. Now because they have already advertised this post, if this post has already been filled in, my lord, my rights will not be there anymore, my lord, because
Definitely, that is what.
has
That is
already
what.
been
So what is the use? You will not get anything by posting.
right, my lord.
That basically puts an end.
Yes.
We do not have to decide upon what legal right you have.
Yes, my lord. Because
So you are a contractual employee.
Contractual employee, and my another contention was it cannot be filled in by another ad hoc employee, my lord. But if it is a regular advertisement and it has been filled in by
this seems to be a regular advertisement.
In that
By
case,
the-
my lord,
But whether this particular post has been filled up or not,
that is a different thing. But then once you initiate it, that is enough.
Wait, what happened, my lord? Negrus was a new institute, my lord, from old campus to new campus.
At least that will confirm
My lord.
that this filling up the post is not more done by, by outsourcing the thing.
My lord, what happened, my lord? Certain posts, my lord, like security, cleaning,
No, that
housekeeping,
is- Those
can be
those
understood.
are still done by because that is the government policy now. Because
These are grade 4 posts, you see, like these are.
my lord. So those are normally everywhere nowadays. We see that
That is
the
but
policy.
then his case is confined to the post held by him. So why should you overstretch it? Shall we close it on the
yes,
basis
my
of
lord.
this?
In Leonard Senior is saying this post has been filled in by advertisement. Then
Advertisement has been set
No,
up.
he could not
if
say.
you can
what
just
is the
confirm
outcome.
once, my lord, by the next date, if it can be whether
It's all
this
right.
has been
See,
filled in or not.
otherwise also we can if you want, you can take instruction. So that will help us in
Well,
closing the matter without passing
Yes,
order
yes.
of details. See, because petitioner's right also is a question because it's a contractual appointment. So he also will have a difficult case.
my lord,
That will not be very easy to get some relief from. Only thing is that this normal basic query by the court is that if some posts are continuing, sir, it is required on regular basis. Then why it should be done in those contractual basis?
my lord, I follow. My lord. I can have that instruction by tomorrow.
Yes.
This is a matter fresh, my lord.
Can be fixed day after
Tomorrow, day after.
Day after tomorrow.
When? Tomorrow
I
or day
can
after?
get it today also, my lord. If the matter is fixed tomorrow, or day after tomorrow, as per Lordship's convenience, I have no problem.
It's not my convenience. It's instruction.
I can get it. It's here only, my lord.
Can be fixed day after tomorrow, my lord.
Release this matter day after tomorrow. Just wait for the learned counsel. Acha, you see, on the prayer made by both the counsels, release this matter day after tomorrow.
Obliged.
Please take instruction. Then it will be. This will be helping. So, like these are also 2019 matters.
Yes.
Unnecessary without any. Why should we keep it pending?
Obliged.
Deeply.
15.
Yes. Yes, Mr. Dahar.
Lordship, they were supposed to bring some instruction to the regards to the
As per the
appointment.
last order, my lord, we are supposed to get instructions on the employment, my lord. This is that matter, my lord, where the petitioner has been terminated, relieved from his duties, my lord. Women's college matter.
Oh, sure, yes. And you said that you are still open.
My lord, we have
Yes.
taken instruction, my lord.
You have instructions?
My lord, we have taken instructions, and my
Yes.
lord, the instruction is that, my lord, as on date, my lord, there is no post, my lord.
So
because
this
of
matter
the-
has to be decided on merit.
My lord.
Okay, we will do that.
Lordship may take this matter some other day. Lordship, my senior is on legs before
Yes.
code 3. Also, so
Yes,
this
Mr. Teachand, Learned Counsel for the respondent submits that at present there exists no vacancy in the college in which the petitioner can be accommodated.
Because, my lord, there is no computer department itself in the college, my lord. So, my lord, otherwise
So,
also.
in view of the submission, the matter requires to be decided on merit. Mr. T. Dahar, Learned Counsel, appearing for the petitioner, prays for grant of some time. Prayer allowed, list after 2 weeks.
1 week, 2 weeks.
Make sure do not take time repeatedly. Take 2 weeks and then take it. Should not be like 1 week, then again 1 week.
Lordship.
List after 2 weeks.
Highly obliged. Lordship.
16.
Please, Lordship.
Yes.
As per the order dated 24/8/2023, the petitioner was asked to substitute the order of permission attached to the petition because the another two petitioner was struck out. In this respect, I were to make a small submission, Your Lordship. Even this petitioner earlier.
Just a minute. Just hold on for a second.
Lordship.
Yes.
Now I supposed to file the affidavit on with the remaining petitioner, Lordship, to stand because another one is struck. Now in this respect, I want to my submission, Your Lordship, because I got the instruction. Even this petitioner number 1, whose name has been struck out, even they have not received those even the salary since from 2018. Even though he has already voluntarily retired. But even he has not received those salary.
Who?
This Fleming B. Marak, petitioner number 1.
Whose name has been struck off then?
Petitioner number 1 name has been.
He has been already struck off. His name has already been struck off.
That's when my submission actually. Later I got this.
See, once the name is struck off, gone. You cannot make any submission on his behalf. He's gone.
No, you want to file a small application to revoke that order. It can be possible because he's still.
It has been struck off on what basis?
Because on the basis that he has
where is the order by
Lordship? It is there in the order dated 23/05/2023.
23/05.
Lordship.
This is something you see like it should not happen.
It should not happen. But what I got is
that you struck off somebody's name and then if you after you striking off, how can you enter with this thing? Where is the provision of law?
Of course, that is another difficulty is Lordship.
Done on the basis of your submission, Mr.
Yeah, Lordship. Yes, because on the another difficulty is those remaining petitioner they are ready to come forward, but it seems that authority
petitioner number 1 and 2.
1 and 2. One is already terminated from service. But then one difficulty that they said.
See, their name has been struck off. If they have any dues pending, let them file a separate application. Why? This application is what? This writ petition.
P-Pay Commission. For implementation of P-Pay Commission.
P-Pay Commission.
And
if any benefit comes, say supposing if any benefit is conferred, this will be automatically go to others also.
Yes, and it will go to me also.
Depends upon.
Yes.
From which date it has been.
Yeah, that date they have indicated in that one in their approval order. And Lordship,
is it a case where you said that there exists a resolution by district council?
Yes, Lordship. They have even partly they have implemented, Lordship. Can you look this one? Because only it is only on the part of salary, in respect of salary, they have not implemented. Otherwise, all others their DA or the retirement is partly implemented. Only in respect of payment of salary, that P-Pay Commission has not been recommended. This is the letter which I got it from. Otherwise, it's implemented.
Yes, it's okay. But then, okay, what is the problem? What right it gives you? That is for them. It is in their wisdom. If they cannot pay, can they force them to pay? They do not have money. They will not implement. This implementing that new pay scale will put some extra burden.
No, other day Lordship was asking me regarding the notification. That notification I will be filing in the additional appeal.
Whether because you referred to a resolution.
Yes.
Now the query was court.
Yes.
The query of the court was whether there is a notification pursuant to the resolution.
Lordship, there is a notification. Lordship, allow me. I will file on additional on the form of
notification by which this recommendation of the fees pay commission with regard to the pay has been implemented. That is what.
Yes, Lordship.
Other things will not help your cause.
Lordship.
Your prayer is with regard to pay.
Lordship.
That is what.
Another difficulty is, Lordship.
Anyway, we are getting diverted. What to do about these things? Oath of affirmation.
One difficulty in
now,
bringing another petitioning.
Oath of affirmation. After the name of respondent number 1 and 2.
Yes, that's why I am trying to. Another difficulty.
So you have to correct it.
Lordship, I will correct it. But only thing is that this I have asked. There are 7 or 8 petitioner. 7 petitioner. They said that they were threatened by the respondent, GSC respondent, not to
file a fire. What this court can do?
They're treating that they want to
You
remove.
want me to go with a gun and then?
No, Lordship, they want to remove. They're treating. They will remove from the service whoever come into their permission on that. That is.
No, if something
they have
happens,
resolution also is there.
Any threatening part and all, you are a lawyer. You know how to take care of that. Your each and every grievance cannot be taken care of by a red court.
Yes. Only
If
thing
you
is that
say there is a threat perception.
They come. They were scared of coming forward for out of affirmation only because they say they were saying that their service will be removed. From
They are not afraid to pursue this case. Why should they be scared of oath of affirmation? Oath of affirmation, nothing. The affidavit attached to the writ petition has to be replaced by somebody else's affidavit, surviving petitioner. That is what. What is the threat in that part?
It seems the authority, the secretary have told them, you will come forward for this one.
File FIR. Have you filed it in FIR? Why you are making this kind of allegation in the courtroom without making a FIR?
No, they have receipts. I bring in the courtroom.
You are making allegation against some responsible officer.
No, it is on record. I will bring that. They have made a resolution. The resolution they have stated. That I will bring it on later. It is on record. Where they?
No, but then what about the last order? When it will be implemented?
Yes, Lordship.
You want some more time for that?
Okay,
I'll just simply give you. This court will simply give you 2 weeks more time, but then.
Okay, 2 weeks time. Then.
Yes. Mr. P.T. Sangma, praise for grant of further 2 weeks time to implement to do the needful as required by this court's order dated 24/8/2023. No objection? You also stand for making prayer, isn't it? The counsel appearing for the respondent has no objection. Prayer allowed, list after 2 weeks. Please do something. See, this kind of submissions will not help you in a writ court. Do something so that we can proceed with the matter, we can finish it. Nothing more. Second half is not needed. Okay.